The Supreme Court has scheduled oral argument in the New York State Rifle and Pistol Association versus Bruen case. It has been scheduled for November 3rd. In today's segment, we're going to set the stage for you about what to expect, what details the Supreme Court is likely to focus on, and how things could play out among the justices. All that and what you need to pay attention to when we return. Hey folks, I'm Mark and welcome to the Four Boxes Diner. The New York State Rifle and Pistol Association versus Bruen case is a case that's coming out of the state of New York where the United States Supreme Court is likely going to decide whether you and I have a right to carry firearms outside of our homes. Now I want to set the stage here. So let me set the stage for you as to what has happened so far and what will have happened before that November 3rd oral argument date. Well, all the parties will have submitted their arguments in writing before that oral argument. These submissions are called legal briefs. There will also be other briefs submitted by interested parties. These parties are called amici, which is Latin for friends. These folks have already put in literally dozens of briefs on specific legal and public policy topics in far greater detail than the parties who are governed by strict word limits would have been able to do so on their own. Now, by the time of oral argument on November 3rd, the judges, for our purposes, or technically speaking, they're justices. Justices on the Supreme Court is what judges on the Supreme Court are technically called. The justices will have read these legal briefs and they will have prepared a series of questions for the lawyers on both sides of this important constitutional fight. Now, the argument itself on November 3rd will last 1 hour. The plaintiffs, who are the ones challenging the New York gun control law, the New York law restricting the carrying of firearms, will be represented by attorney Paul Clement, an excellent constitutional attorney. And the attorney defending the law will likely be someone from the New York State Attorney General's office. It can be difficult to determine which way the court is going to rule based on oral argument alone. But there are a few key justices to pay particular attention to, and there's a few key issues you should be aware of. Let's start with the justices themselves. You see, there's 9 Supreme Court justices on the Supreme Court. So to win a case, the plaintiffs need to win 5 votes. 5 of the 9 justices have to vote for the plaintiffs to win. Now, let's review how to look at some of these 9 justices from our point of view as people interested in supporting the Second Amendment. Well, first off, there are the 3 so-called liberal justices who, in my opinion, are lost causes when it comes to the Second Amendment. Now, those liberal justices who are lost causes when it comes to the Second Amendment would be and are Justice Stephen Breyer, Justice Sotomayor, and Justice Kagan. That's Breyer, Sotomayor, and Kagan. Breyer, Sotomayor, and Kagan. So you can, in my view, you can pretty well ignore what they have to say at oral argument because they're going to rule against the Second Amendment. You can basically take that to the bank. Now, there are 4 justices who, in my view, and the views of many others, have very strong records on the meaning and support of the Second Amendment's right to keep and bear arms. Now, these justices who have, to me, unequivocal support of the Second Amendment viewpoint that I think most subscribers here would support and would hold are Justices Clarence Thomas, Sam Alito, Neil Gorsuch, and Amy Coney Barrett. Again, Justices Thomas, Alito, Gorsuch, and Amy Coney Barrett are 4 justices that I think if you look at their track record on the Second Amendment, it's very likely they're going to be supportive of the strong individual rights interpretation of that amendment. Now this leaves, if you're doing math, 2 justices we haven't talked about yet. That leaves Justice Brett Kavanaugh and Chief Justice John Roberts as the so-called swing votes. And a swing vote, of course, means the person or the people that are going to determine the outcome of the case and what the opinion will ultimately say, because they're going to be the ones determining whether or not you get 5 votes or less than 5 votes for the plaintiffs to win. Now, we know that Justice Kavanaugh has written eloquently and expansively about the Second Amendment. So I'm very optimistic, which I frequently said on Fox News back during the confirmation hearings of Judge Kavanaugh, that I'm very optimistic that Judge Kavanaugh, now Justice Kavanaugh, will rule in favor of the right to carry a firearm outside of the home. But he remains a swing vote because we just don't know, of course, how he or really anybody else is ultimately going to rule on this question. Now, Chief Justice Roberts has consistently tried to shy away from addressing politically controversial topics. So to me, in my opinion, it's really, really hard to know how he's going to approach this particular case. Okay, before the passing of Ruth Bader Ginsburg, John Roberts was known unequivocally as the 5th swing vote. Whichever way he voted was how that particular controversial political oriented case would come out. So if he sided with the so-called conservatives, so-called conservatives would win that case. If Roberts sided with the so-called liberal wing of the court, then the liberals would win that particular case. Of course, that changed when Ruth Bader Ginsburg passed away in 2020 and was replaced with a confirmation to the Supreme Court of Justice Amy Coney Barrett. Now, the bottom line for you as viewers of the Supreme Court and as people interested in the Second Amendment, the bottom line is that you should pay particular attention to the questions from Justice Kavanaugh and from Chief Justice John Roberts, because it is their votes who may decide this case and whether you have a right to carry a gun outside of your home. As to the substance of the case, you want to look and see whether the key justices are asking questions that concern the text and history of the Second Amendment, or are they asking questions that concern more modern day controversies involving guns and gun rights. You see, there's a big constitutional debate among judges in the United States and justices on the Supreme Court. Okay, there's a big debate among judges and among other places, the lower courts, as to the best way or the most appropriate way to interpret the meaning of the text of the Second Amendment. Now, traditionally, or I'm going to be general here. Generally speaking, I would say that more conservative-oriented judges who are supportive of the Second Amendment's right to keep and bear arms follow in the language and teachings of the Supreme Court's decision in Heller versus the District of Columbia, which was the pivotal 2008 Second Amendment decision that was authored by the late Justice Scalia. These justices focus on the words or the text of the Second Amendment, and they also focus on the history surrounding the enactment of the Second Amendment in 1791. Now, this approach to interpreting the Second Amendment is called, generally speaking, it's called the text, history, and tradition test. A faithful application of the text and the history of the Second Amendment, to me, would certainly require the Supreme Court to acknowledge that it protects a right to carry firearms outside of the home. Now, as a gun owner, there are several important things that you want the Supreme Court to decide, as I see it. First, as a gun owner supporting the Second Amendment, you're going to want the Supreme Court to decide what is the proper standard of review for this case and future Second Amendment cases. And you want them to decide that the proper standard of review for this Second Amendment case and future Second Amendment cases is in fact that text, history, and tradition test. Relatedly, you or we would want the Supreme Court to reject reject and throw out the window any sort of balancing test. When you hear the words balancing test or a cost-benefit analysis or weighing of the rights or anything like that, sometimes it's referred to as the tiers of scrutiny test. You want to have your ears perk up and say, no way. We want the court to reject any sort of balancing test, such as the tiers of scrutiny test, which I've talked about in another video you can check out later, which allows judges to weigh the importance of a constitutional right on the one hand against some sort of governmental interest on the other hand. You do not want any sort of balancing tests when it comes to the Second Amendment. And why is that? It's because, and I will tell you here and now, balancing tests basically allow the judges to almost always hold and rule in favor of the government against gun owners. If you hear balancing tests, it means the government is going to win and the gun owner is almost certainly going to lose, because that's why many courts, especially those supported by liberals, embrace balancing tests involving the Second Amendment. Now, second, here's another thing I want you to pay attention to and watch out for. Gun owners want, in my view, gun owners want the Supreme Court to explain that the language right to bear arms means that you have a right to carry guns outside in public. The text means you can carry guns in public. And third, gun owners and people that support the Second Amendment want the Supreme Court to review carefully the history of our country at the time of its founding, which is probably, there's a little bit of a scholarly debate about this, but which is probably the time period, in my view, I think it's really between 1760, right, and 1826. And I say 1760 because, you know, it's about 16 years, of course, before the Declaration of Independence. You got that run-up of British bad behavior in places like Boston, among other things, and then the Declaration of Independence, and then you have the Revolutionary War. And I think the founding period extends, of course, through the enactment of the Constitution and the enactment of the Second Amendment in 1791. And the reason why I stopped the founding period, I think the court will as well, in the year 1826, is because on July 4th, 1826, we have on the same date the death of John Adams and Thomas Jefferson. And I think with their passing, the founding generation and the founding part of our country at that point has really ended. And now we move on, of course, to a new phase in American history. So I think the founding period, and we want the Supreme Court to basically say the founding period is that period of 1760 to 1826. Now, during this founding period, though, the history teaches us that Americans were allowed to carry guns peaceably outside. So it was clearly understood that the meaning of the Second Amendment protects the right to carry guns outside the home. And we want the Supreme Court to really get into that and explain that in great detail and find that that was the case. Now, if you're a liberal, I'm going to give you a little bit of guidance. If you're a liberal and you hate guns and you want gun control, for those people from the anti-gun community that tune into this channel, let me tell you what you're going to want. You're basically going to want the opposite decisions from what I just said from the Supreme Court. And most importantly, if you're an anti-gunner, you're going to want the Supreme Court to agree that courts, especially lower courts, should be allowed to balance the rights of the individuals away in the name of government power. Why? Well, again, as I said, as a practical matter, that's because liberal judges tend to focus on the modern day policy debate about whether guns make society safer or dangerous. And we can have that debate, and we certainly talk about that in other segments, but there is a debate about that. And in essence, the liberal judges in the United States like to engage in social balancing tests, or a form of what we would call in philosophy utilitarianism, doing what's best for the greatest number regardless of individual rights. Now, the fancy legal term for this balancing test approach is the application of what's called the tiers of scrutiny. Sometimes it's called strict scrutiny, sometimes it's called intermediate scrutiny. Regardless, this approach is basically a blank check for lower court judges to erase Second Amendment rights guaranteed by our founding fathers, and to erase these Second Amendment rights by discussing modern left-wing academic quote-unquote research, right? And then ruling that the state or the county or the town law had some sort of valid reason for restricting the exercise of our fundamental Second Amendment's right to keep and bear arms. To wrap up, as we move forward, we're going to talk a lot about this New York State Rifle and Pistol Association versus Bruen case. And as we move forward and continue this process, we're going to watch the Supreme Court's Bruen case with all of this in mind. And we want you to keep in mind that the two key justices for this case, the two key justices, are Justice Brett Kavanaugh and Chief Justice John Roberts. And again, I want you to pay particularly close attention to whether at oral argument on November 3rd, they ask questions about the text and the history of the Second Amendment, which if they do so, I take that as a good sign that the gun owners are quite likely going to win that case. Or, of course, if instead we start to see the Supreme Court really focused on questions concerning modern research relating to so-called gun violence, that may not be a good sign for the gun rights community. Now again, it's always very difficult to predict a result based on questions at oral argument, but these are the key issues to be on the lookout for. And as we get closer to that November 3rd oral argument, stay tuned to this channel because I will be working to try to bring you ongoing updates as developments do occur. So thanks for joining me here today at the Four Boxes Diner, where again we serve hot, fresh Second Amendment news and analysis on a daily basis. So if you like what you've heard, please subscribe to this channel and help spread the word. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.